provisions by way of general rights of appeal. It may be noted that the context here is legislative competence. Therefore, what was relevant was not the type of appeal encoded in the Criminal Procedure Code and the CPC, but rather the categorization thereof in terms of their nature. Thus, a general right of appeal was included in the legislative competence of the concurrent list, my lord. So, as far as legislative competence is concerned, when you're looking at entries, then it is not a presumption that the competence to have law on appeal would fall within a category which does not deal with procedure. It can deal with procedure. At least that is what it's saying.
Mr. Faisal, and I think that is echoed, I might not have looked at this, but I found 53 Lahore, 284. It's a DB judgment, and I just read this paragraph, which is important.
I found it very interesting, but I may be misreading.
Which actually talks about exactly something like this, which needs to be discussed, which is a letters patent appeal is not really an appeal in the strict sense. It may be more aptly described as an internal arrangement court for reviewing its own decision, given in the first instance by one member of the court. Then the first as well as the second decision remains a decision of the court. And if you look at Order 5, Rule 2 in the rules,
there's a chamber appeal.
There is a chamber, it doesn't say appeal, it says for reconsideration to a 3-member bench. So three judges, if you see Order 5, Rule 2. So, I mean, before going into 55, let's this out whether at all this could form part of having an intra-court appeal.
Rule 3, Order 5, Rule 3 says appeal. Rule 3 says an appeal shall lie from registrar in all cases to
as registrar.
From
Agla pade na?
To the judges in chambers.
That's
it's
right.
an appeal.
And then there is from a single judge to 3 judges.
Administrative order, and that's an administrative appeal.
But it's still an appeal.
Not a judicial order.
It's still an appeal, and it's framed under 190.
Fair enough. I mean, it probably has a color, rightly said by my colleague. That it could be administrative in nature, but we need to understand the context. If you look at Order 5, Rule 2, it talks about the power of the court in relation to power.
In relation to the following matters may be exercised by a single judge.
Can you tell us where are you reading from?
Order 5, Rule 2, Order 5, sir, Supreme Court rules.
The power of the court.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chamber, but subject to reconsideration at the instance of any aggrieved party by a bench of not less than 3 judges, which may include the judge who dealt with the matter. Your Lordship is right.
It refers to reconsideration. We don't know where to slot it. It is probably administrative in nature also. But what I'm trying to say is that intra-court appeal under these 3 judgments that I've looked at are talking about it is an internal setting and a procedure and arrangement and not considered to be substantive in that sense, which has been echoed elsewhere also. Yes. So whether at all it becomes part of a procedure of practice and procedure rather than as a substantive right.
I think this note opens up that question. If I may just read the last paragraph and then Your Lordship. Sir, as far as Justice Hassan Azhar Rizvi's opinion, which basically dealt with the merits of the case and a paragraph on the intra-court level. There's a paragraph in Justice Munib's opinion on that, which is also very important. If Your Lordship may kindly see page 25, para 12.
Para 12?
Ji, sir. Page 25. In view of the above discussion, I am in no doubt that the question to me ought to be answered in the affirmative. It is so answered accordingly. I also agree with my learned colleague Hassan Azhar Rizvi that leave to appeal should be refused and leave petition dismissed. Usse upar jo hai 4 लाइनें वो है in contrast. My learned colleague Sayyid Hassan Azhar Rizvi has rightly noted in an order. See para 15. Now para 15 flows from para 14, dependent on para 14. That despite lapses of more than 50 years from the promulgation of the ordinance, no such question called the legality of the ordinance has been raised by any party lawyer, any high court or this court, my lord. And para 14 dealt with 2 things. There can be an intra-court appeal from a constitutional judicial forum, and secondly, the legislative competence based on Article 175, sub-Article 2, my lord.
See, Mr. Counsel, the thing is that you are, of course, referring to my order.
Yes, sir.
It is an order of the court, and therefore it is for others to make of it what they will.
Yes.
It is not for me to now read and interpret it, but I am picking up on the point that you think flows from this order.
Ji.
Seems to me, with respect, that it cannot conceivably flow from this order. The reason is that the issue before the court or before me as the referee judge was a right of appeal conferred by statute, right? And as you have read, I have noted two kinds of appeal and the jurisprudential aspect of it and the language of entry 3 of the current list and so on and so forth. However, to translate this into practice and procedure as embodied in Article 191, in my view, would, and that is certainly not what this order was about, but would be incorrect. Why? For two reasons. One, because the subject matter of practice and procedure, insofar as law is concerned, you have told us that in your view it is limited, restricted, supervisory. It is not the entire breadth of the practice and procedure of the court. So if that is so, then no law which is so restricted, which is of a supervisory law-making capacity, which is restricted, supervisory, restrictive in nature, surely can confer a right of appeal in terms of that subject matter.
I think it can.
Just one more. Yes. Secondly, and more importantly, the subject matter, practice and procedure of the court is not restricted to the legislature. It is open even to the Supreme Court.
Yes.
It is primarily for the Supreme Court. So one conclusion that would follow from what you are saying is that the Supreme Court can itself create a right of appeal in exercise of practice and procedure. Is this what you are arguing?
My Lord.
In relation to Section 5 now.
My
The
Lord.
context
My
here
Lord.
is Section
My
5.
Lord.
So tomorrow the full court amends the Supreme Court rules and creates a right of appeal. Can
My
it do
Lord,
that?
my Lord, I make two alternative arguments when it comes to the legislative importance
Mr.
of
Faisal,
appeal.
before
Ji,
going to
ji, ji.
answer the question
Ji,
of my lord,
ji.
please complete that page 18, paragraph number 16 of my lord Hassan Rizvi. This is
Sorry?
very interesting paragraph 16, page 18.
Para 16, sir. हाँ सर जी जी ये भी बहुत इंटरेस्टिंग है आई एम सॉरी दिस इज आल्सो क्रूशियल टू दिस मैं पेज 18 पे हूँ सर पैरा 16 it's very important that what Justice Hassan Rizvi has reminded us is very important to be reminded all the time. Para 16. Surprisingly, this question, page 18, surprisingly this question has also not been raised in this case, but it has been taken up by my learned brother on his own. The process of judicial scrutiny of legislative acts on the touchstone of the Constitution is technically called judicial review. The courts, however, should adopt judicial self-restraint in discharging their functions of judicial review in order to maintain harmony between the judiciary, the legislature, and the executive. The power of judicial review of legislative acts vested in the High Court, and this court must be exercised with freedom, wisdom and self-restraint, and not in a spirit of cold war between parliament or state legislature and the courts. Non-interference with the view of the majority in parliament with regard to what is reasonable and interference with what is prohibited by the Constitution may perhaps be a harmonious path for a peaceful transition for a glorious future. In Lahore Development Authority versus Mrs. Imran Tewana, 2015 SCMR 1739, this court, while stating the rules which must be applied to declare laws unconstitutional, has held that if a case can be decided on other or narrow grounds, the court will abstain from deciding the constitutional questions. So, my lord,
Sir Siddiqui, on a lighter note, if I may compliment you, what apparently were apparently divergent views, you have to reconcile all of them.
sir, I try to read everything which your lordships write, whether
Harmoniously.
reported or unreported. Sir, now I'll come back to this, but my reading of your lordship's order is that if, for the purposes of legislative competence, appeal is a part of procedural law, if that is so, then Parliament can also confer appeal.
Not all appeals, but intra-quota.
Intra-quota. 191 read with 58, and the court can also do that.
Court can also.
Yes, the court can also do that. Why is appeal not a restriction? I think an appeal against orders passed under 184(3) are not liberating, are not restrictive. They would be liberating, because it is a problem that there is no appeal against such tremendous power exercise.
This Order 5, Rule 2 that you read, even
Yes.
though we would certainly consider it as an administrative appeal, but practically it is an appeal provided it determines the right of the parties, and the rules are providing for that appeal.
Yes, yes. So this is one way I can, that legislative competence.
I've recorded your contention. Correct me if my understanding is correct. Intra-court appeal liberating, and both Supreme Court and Parliament can provide for them.
Yes, yes.
Okay.
Yes.
And why
They
did-
are not always
if
restrictive,
I
my
may-
lord.
If I may follow what my learned colleague has said with regard to Order 5, why
I
didn't they
can't
use
hear
the
you.
word-
I can't hear you. I mean, sir, I can't hear you.
I'm so sorry. What my learned colleague said, Order 5, it's why do the rules use the word reconsider? Why not simply call it an appeal? Because read it, आप उसको पूरा पढ़िए ना, आप उसको kindly पढ़िए. There's a reason why it's called reconsider.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of an aggrieved party by a bench of not less than 3 judges, which may
include the judge who dealt with the matter.
Yes.
It cannot be an appeal. This is not an appeal because it cannot be an appeal.
So
If
this
it
is
were
a
an
review?
appeal, this
This
is
is
not
a
a review.
reconsideration.
This is a reconsideration.
Sir, it is like a review then.
No, it's not.
A review, practice and procedure में review का power confer कर दिया.
ये देखिए ना,
अगर-
deliberately
In an appeal, can't a judge who passed an order sit?
Sir, that is not the notion of how things are.
I suppose he's one judge. I
Sir,
don't know. For instance, I'll just give you another example. A bench, their divergent views, right? And the matter is referred to the Chief Justice to send for opinion of the third judge. Alternatively, what could happen alternatively is because one set of arguments were, the third judge hasn't heard the arguments as well, or that particular question as articulated was